All rise. Court of Appeals, Division 1 is now in session.
Please be seated. This is the time scheduled for oral argument in our case number 1CACV 13-0119, Roberts versus Del Webb Communities, Inc. et al. Each side has been allocated 20 minutes for oral argument. If the appellants desire to reserve any time for rebuttal, you can do so. You may do so, but you have to, there's a clock in the podium, and you'll have to manage your own time. The time that shows left includes your rebuttal time. To assist you in this regard, you should be aware that we have read the briefs, we've looked at pertinent portions of the record and cases, and we have conferenced this matter, so you can guide your argument accordingly. Also, please be aware that we are audio recording and video recording these arguments. So when you approach the podium, please clearly state your name and who you're representing. With that, counsel for appellants.
Good morning, Your Honors. Bill Nebaker on behalf of appellant Del Webb Communities. And I will reserve hopefully 5 or more minutes for rebuttal. I thought I'd start off with at least the comment that I don't think, in spite of the fact that the record is voluminous, I believe, that there's a whole lot of factual differences or facts that are actually in dispute. Basically, it comes down to, I believe, somewhat of a legal argument. It obviously comes down to a question of Mr. Barden and whether he was working as a consultant, independent, or actually working for the law firm. But the facts that I think are important, and the reason why this appeal is so important is, quite frankly, I've been doing construction defect work now for 25 plus years, and it's always been somewhat of a strange feeling for me to look at the way ethical obligations are more or less thrown by the wayside. Obviously, these types of cases started in California, came to Arizona in the 2000, late 1990 timeframe. And really this case and these facts lend themselves to the typical, stereotypical type of construction defect case. I don't think the facts are in dispute that there were over 10, I think the number is maybe 12 solicitation letters that started this lawsuit. I don't think the facts are in dispute that the investigation, when it did take place, took place after the solicitation letters were sent out. I don't think it's in dispute that this type of case is what you typically see, i.e. big, large developments such as Sun City Grand, but it could be, it could be Terra Vita, it could be Anthem, it could be, any of the master plan communities that we see out there, and it doesn't necessarily have to be Pulte. It can be D.R. Horton, Toll Brothers, Shea. They're all targeted, and this is the way the cases start, and this is the types of cases that routinely in the construction defect world we see all the time. The interesting part about it is that superimposed over that is a law firm making a conscious decision to target a subdivision, a master plan community, and then using their usual captive experts to assist them in preparing their case and, quite frankly, assist them in getting clients. And I've looked at these cases over the years, and it almost becomes evident that the clients really are the houses, not necessarily the people living in them. And quite frankly, it becomes almost a fungible commodity. As you can see from the development of this case and how it progressed, the opportunity now is for this court to look at construction defect and perhaps give us some guidelines in terms of how things should be done in prosecuting and or preparing or even achieving these types of cases. Now, the problem, quite frankly, is that as we sit here today, the court's probably not aware of this, maybe you are, Mr. Weber and I and his firm and I are in trial in front of Judge Reyes on the other half of this case, and we have been since November. So we are now litigating.
Glad you're here with us then. Thank you.
Well, if you know anything about Judge Reyes, he's back in Washington, D.C.
I kind of thought
So we had this week off, so it was fortuitous that we could take the time off and actually come out down here and see you. We were planning on, taking a break anyway, but so there's both sides of this case. There's the arbitration case, and now working its way up through the Superior Court system is the trial court side of this case. And that's important because if you looked at part of the brief where you saw the part about the collateral estoppel, we have had rulings by Judge Reyes, and quite frankly, you'll probably see these in front of you in a few years. But these are the collateral. We've been collaterally estopped from asserting some of our defenses based upon the arbitrator's decisions in the underlying arbitration. So it's almost. And that goes to, I guess, the real first part about my argument, and that is deference to an arbitration is certainly an admirable and certainly a worthwhile goal because, quite frankly, you don't want to be seeing a bunch of appeals from arbitrations. You want it to be done, over with, and gone. The difference is this is a little different arbitration. I think if you look at the terms of this arbitration agreement and the intent behind it, it was designed for a fast, efficient, expedient method by which somebody who had a roof problem or somebody who had a window problem could come to Pulte and say, I want this taken care of. Pulte says it's not our fault. Let's go to arbitration. It's done. This one was stood on its head by consolidating 460 homes into one with a myriad of defects that, quite frankly, the homeowners didn't even know that they had. Manufactured, quite frankly, is my client's position, for the most part, by the experts. It lends itself, again, to something that I think is important for this industry and for this court to consider.
Mr. Nebucher, if you don't mind, could I go ahead and ask you some questions about
absolutely,
Mr.
yeah.
Barden? And I don't mean to take you off your prepared remarks, so if you don't mind, because time is fast speeding away from us. This is my question, having looked closely at the briefs in this and the argument about Mr. Barden was really a contingent fee expert. At pages 22, 23, and 24 of your opening brief, you reference a number of exhibits. Now, I just want to make sure I understand the state of the record that was before the arbitration panel versus the record that was made before Judge Cooper, okay? So that's really what I'm asking about. As I understand it, the Rhodes Declaration and the Shealy Declaration, these were declarations that were prepared and given to Judge Cooper and not the panel, is that correct?
Yes.
Okay. There are also some exhibits here that collectively compiled a number of invoices or other billing records from Mr. Barden. Were these billing invoices or records submitted to the panel as part of the motion to preclude his testimony?
Yes.
Or were they only submitted to Judge Cooper?
No, the discussion concerning how he billed, what he billed, all of those things were submitted to the arbitrators.
So, for example, and you may not have these memorized, but when I look at, I think I looked at 118 or 119, I looked at some of the chunks of invoices. Those materials were given to the panel.
They had them available, yes.
Oh, okay.
The thing I'm having trouble with is if you go to 260, 261, I'll give you the exact, 257 through 261. Those were the, our attempt to reconcile how Mr. Barden billed.
Those were your work papers by counsel for Del Webb?
Right, and so we went through and we tried to figure out which ones he wasn't paid on, which ones he was paid on, which ones he was paid more than he billed, which ones he was paid less, and I think there was a fifth category.
And 257, 261, were those reconciliations or your analysis, were they provided to the panel, or was that only to Judge Cooper?
That was only to Judge Cooper.
Okay. Let me tell you my next question in light of this. When I was examining this issue, it seemed to me that whether Mr. Barden actually was a contingent fee expert raised a question of fact that the panel had to decide. And implicit in its decision is a determination that, based on the evidence Del Webb presented, that he was not a contingent fee expert. And that's why they very carefully said, based on the record and the evidence presented, his dealings with plaintiff's counsel goes, I believe they talked about, forgive me, I'll have it right here. It goes to, I think, weight and credibility, not its admissibility. So, my concern here is that you have raised a number of legal arguments, public policy, manifest disregard, but at bottom, isn't this a factual issue as to whether Mr. Barden was a contingent fee expert? The panel disagreed based on the evidence presented, and that's not something the Superior Court should reconsider, nor should this court reconsider.
If that were the state of the record, I think you'd be accurate and correct.
Okay.
But I don't think that's the state of the record. Quite frankly, the panel basically said, we don't care, we can figure it out ourselves, we're going to let him testify. And that's the real gravamen of our argument.
But where do I find that? What I have here is a June 9 order, and I don't see them saying, we don't care. I see them saying, the concerns expressed in the motion about his alleged bias go to weight and credibility of his testimony and not its admissibility.
Right, and that the point I think I'm making is it doesn't go to that. I think the record is clear that they can't overlook an ethical violation and still allow someone to testify.
But if he's not factually a contingent fee expert, I know you disagree, but if in fact the panel found as a factual matter he was not, there's no ethical violation. Laus is not implicated.
But they never made that determination. All they
I think
said.
it's implicit in that, saying
No.
it goes to weight and credibility, not its admissibility.
No, because I think they said basically if he wants to violate ethical rules, we will take that into consideration regarding his bias and give it due credibility as to what we think we should give it, give it the weight. But again, I think it should have been struck and it shouldn't have been part of the record.
But what about when they say having considered the written submissions and oral argument? I've read your submissions. You very strongly argued that Mr. Barden was in fact a contingent fee or on a contingent fee arrangement with counsel. And you cited the applicable Arizona case law. So they had it all there and they say they considered it.
Well, they said it goes to the weight. They didn't say they considered it. They didn't make a factual finding that, no, we disagree with what you say. They didn't say, no, he wasn't. I think it's implicit that they basically said, we don't care that he's a...
Well, didn't they say respondent's motion is not well taken?
Right. And
Okay.
I don't think it's clear what that means, other than they want deference to their own thinking as opposed to the factual record that I think sets forth the fact that Mr. Barden actually was and continues to be part of the, quote, Kasdan team sharing in fees. I should add, and it's again not part of the record, that Mr. Barden testified in the Zelkin trial that he's now owed $8 million. So
That's not part of our record.
No, I
is
know,
it?
but
Yeah.
it just keeps going up, and it's still, it's still part of the ongoing
I
ongoing
noticed
problem.
in most of the cases, at least the Arizona cases and the federal cases that were cited, there wasn't any doubt about the contingency. Because in the Lawis case, the witness was trying to recover, and
Right.
the court said, you're out of here. And Weston, Tucson, the lawyer had submitted the affidavit, and the trial court and the appellate court found no sanctions. But in looking at that, at least most of the cases that I've gotten through so far, the contingency seems to be clear. It doesn't seem to be a fact question.
And that's the problem we have, is because Mr. Barden will never admit that he has an interest in these cases and gets paid according to their outcome. But the facts are, if it walks like a duck, I mean, it's there. I think there's plenty of facts for this tribunal to look at that.
Let me then come about it a different way. Was there anything although the panel ruled as it did, when it came to attorney's fees, was there, some sort of remarkable similarity between what they were seeking in cost for Mr. Barden and, a percentage of, the interim award?
Well, the fee part, the attorney fee part, was based on a contingency.
Well, I understand that.
And
I'm not worried
and-
about the law firm.
Right.
We're talking
Right.
about Barden.
Interestingly enough, Mr. Barden and the rest of the experts all added up to about the same $3 million number as well. I don't know that I can draw a conclusion, and I don't think the court can draw a conclusion that because they're both $3 million, that there was something.
I was just trying, since you
Nefarious
had
about
in
that.
between 257 and 261, created, looking at it a different way, maybe there was another way to get to the,
I'm running
More
into my
impression.
reserve time, so let me finish at least just one more thing, and that goes to the expert fee, that $3 million. Again, I think you've been briefed, you've read the briefs, but really what it boils down to is two things. Construing costs to mean fees certainly isn't part of this contract. It certainly doesn't say that. All the cases that were cited by the opposition, the claimants, basically had additional modifying language somewhere in that arbitration agreement that allowed the court to go further and say costs could mean something else. Ours doesn't have that. More importantly, Rule 53, basically the rules under which we had the arbitration basically say both parties are to pay for their own witnesses. And I'll reserve the rest of my time. Thank you.
Thank you, counsel. Counsel for appellees.
Good morning, Your Honors. May it please the Court, Thomas Hudson on behalf of the plaintiffs' appellees, and with me today at counsel table is Stephen Weber and Michael White. Your Honors, this case is about a large home builder who required home purchasers to sign an arbitration provision and is now complaining about the outcome of the very process upon which it insisted. But as the panel's award makes clear, and as the record in this case makes clear, Del Webb received ample due process and received a fair hearing. The panel considered over 10,000 exhibits, heard sworn testimony from over 500 witnesses, including extensive expert testimony, ultimately issued a comprehensive and careful decision that made clear that there were defects in these homes. In fact, Del Webb's experts, as we know from reading the award, conceded that there were defects in the homes. The Superior Court then held an evidentiary hearing at which it gave Del Webb the opportunity to prevent any additional evidence that it desired to do so to demonstrate its points that the award should not be confirmed pursuant to the Federal Arbitration Act. We submit that the record in this case makes abundantly clear that Del Webb woefully failed to meet its burden. Now, I don't intend to discuss each of the points raised in the briefs. We think the briefing's more than adequate. But in light of the panel's questions concerning Barden, I just wanted to make a couple notes and, of course, answer any other questions the court has, and then briefly discuss post-judgment interest and the issue of fees on appeal. Judge Norris, if this were a review of a Superior Court order and we had what the panel had done here in its order, where it says, I've considered everything, it goes to weight, not admissibility, this court would assume that the Superior Court made all the necessary findings to support that judgment or that order. And certainly the rule can't be more stringent in the context of an arbitration. And then, of course, as we noted in our briefing, when you actually look at the standards, if you look at the standards governing manifest disregard, public policy, and so on, they woefully failed to meet any of those standards. And one other sort of point that I think is worth emphasizing in the context of this case and this record, what was presented and what the Superior Court ultimately admitted were excerpts from transcripts that Del Webb was having made at the time of the arbitration hearing. If you look at the hearing transcript at pages 70, line 13 through 71 through 7, what's noted and I don't think will be disputed is that
Hearing transcript
before Judge Cooper, yeah, that the way that transcript was developed is that Del Webb during the arbitration hearing said it was going to have a court reporter there for purposes of personal note taking, and then in fact wouldn't share that with the plaintiffs in the case. After the award came down, then Del Webb moved to admit those transcripts in the Superior Court, and the Superior Court did that, so they are part of the record. But take a look at Exhibits 74 and 75. We know from those two exhibits that were also admitted that the transcript's incomplete. And we also know from those exhibits that Barden did testify and was thoroughly examined on all of these issues before the arbitration panel. But we don't have all of that. We don't have the full transcript of the arbitration hearing. And so my point is, again, sort of just another rule that would apply in any ordinary appeal. If the record's incomplete, this court assumes that what's missing would support it. And again, the standards are higher in the context of an arbitration award. But I just wanted to emphasize those two points. Unless the panel, I guess let me just, in light of the questioning, let me just note one other minor point on the public policy issue. The cases they cite in their reply note a couple of things that are worth mentioning. One, that if the public policy issue itself is submitted to the arbitration panel, we're done with the issue. Two, that it is, of course, an unsettled issue after Hall Street, whether it's still a valid basis. And three, the cases all agree there has to be an express and an explicit policy. And I too read Judge Portley, the Arizona cases that were cited, the Laos and the Weston case, and neither of those cases involved the admission of a testimony of a so-called contingent fee expert. The comment to the ethical rule says that that's the rule in most jurisdictions, but it's never been spoken to, as far as I can tell, by an Arizona court. And the Weston case is kind of interesting because what the party in that case was asking that a party that was seeking to exclude a contingent fee expert should be sanctioned under Rule 11. And the court said, well, we're not going to impose sanctions for that. So, again, a minor point, but there's no way, given the state of the law, that you could say there is a clear and express public policy. There's no way, given the state of this record, that you could say that it was violated. There's evidence and testimony that Barden was not a contingent fee expert, and that's precisely the type of fact issue that's left to an arbitration panel to resolve.
We don't need to reach the public policy issue if we're saying it's a fact issue.
Correct. So unless the panel has more questions on the vacatur arguments that have been made, let me just briefly mention the issue of the interest on the prejudgment interest on the award and the issue of fees on appeal. With respect to prejudgment interest, Arizona law is clear that a party is entitled to prejudgment interest as a matter of right when a claim becomes liquidated. And I don't think there's any dispute about that between the parties. Arizona law is also clear that once an arbitration panel issues an award on a claim, that claim becomes liquidated. And we would submit that what happened in this case by having an interim award on compensatory damages, which makes clear that all that remains is fees and costs, and then a later award on fees and costs is no different than a bifurcated trial where you have a jury first making a finding on compensatory damages and then a finding on, say, punitive or attorney's fees as damages.
My recollection is the argument's actually stronger, because once the panel issues its interim award and says, this is the award on consequential damages, or on damages, for reserving attorney's fees and costs, it's very, very limited that under the rules, under most of the AA rules, that they can revisit that issue.
That's correct, Judge Kessler.
And unlike a superior court, where even though, let's assume that there's a minute entry that says, okay, I'm awarding $10 million in damages, you could have a motion for a new trial or a motion to vacate the judgment.
Absolutely. And so my point is, we know a jury verdict liquidates that claim, so certainly an arbitration award does. Yeah, you're absolutely correct, Judge Kessler. Well, then let me just mention lastly, again, and I'm happy to answer any and all questions on the merits. With respect to fees on appeal, the opening brief made a request for fees on appeal and cited only RCAP 21, the procedural rule, which, as the panel knows, is insufficient. We, in our answering brief, requested fees pursuant to the contract, pursuant to ARS 12-340-101. In the reply brief, then there's now a new argument that the court can't award fees on appeal with a citation to a Seventh Circuit decision called Menke. Setting aside that that's a new argument in the reply brief that the court can decline to consider, the federal law is clear that if there's a provision in a contract pursuant to which fees can be awarded, the court can award fees. That's what Menke says. And the supplemental citation we gave to Lagstein makes clear that if there's a substantive law provision for fees, some substantive basis for fees, the court can, of course, award fees under that provision. The FAA is silent. In other words, the FAA doesn't say anything about fees one way or the other.
It's a state law issue, isn't it?
It's a state law issue, yes. Yeah.
Does the revised Uniform Arbitration Act, the Arizona, there was the Uniform Arbitration Act that Arizona adopted, and then I think in 2010 the legislature passed a revised one. Which one applies?
Well, in this case, Judge Kessler, it's our position, and the other side agrees that for purposes of evaluating the arbitration, it's the Federal Arbitration Act.
But for purposes of fees, I mean, there are some provisions in the revised Arbitration Act that talk about arbitrators and courts being able to, well, I guess arbitrators being able to award fees.
Right.
So it wouldn't matter, because the question
matter.
really is Arizona's substantive law, whether the court is going to award fees.
That's correct. And what we would, and as a matter of Arizona substantive law, Judge Kessler, this court can look first to the provision in the contract,
Right.
which says any court or arbitrator hearing any matter on appeal. So any court hearing any matter on appeal may award fees. That's section 6.4.12, and it's on page 84 of volume 3 of our appendix. And of course, we know that ARS 12-341-01 provides for fees in any matter arising out of contract. A proceeding to confirm an arbitration award is a matter arising out of contract. This isn't cited in our briefs, but the Ninth Circuit has said that in a case called United States versus Park Place, 563 F. 3rd 907, page 919, with respect to the FAA. But the concept, that has to be right, because arbitration, by its very nature, is contractual in nature, and what we're here doing today is fighting about an arbitration award that arises out of
And we
contract.
don't even need to worry about that, because we've got the contractual
You've got the
provision.
contractual provision. That's right, Judge Kessler. So unless the court has further questions, I'm going to take a lesson from Judge Thama's recent article in the Arizona Attorney and recognize that this is a simple case. We would ask the court to affirm the award and award fees on appeal, and we would ask, in recognizing the court is busy and has a heavy caseload, but to the extent possible to rule promptly in light of the circumstances of many of my clients. Thank you, Your Honors.
Thank you. Any questions? All right. Thank you.
Let me address the attorney fee issue real quick. 12-341.1 cited by the claimants here. If I read North Peak correctly, this is not, it isn't applicable to this type of proceeding because the plaintiffs were pursuing an implied warranty claim, not a contract claim.
Let me ask you about that. When I read the sale agreement, and I look at the arbitration clause 5.5, it says, any controversy, claim or dispute arising out or related to this agreement or your purchase of the home shall be settled by arbitration. And then I tie that into 6.4.12, in the event of any arbitration or mediation between us, et cetera, et cetera. It just seems like the two of them together basically authorize a court to award attorney's fees under the contract. It doesn't matter whether they go under an implied warranty claim or express warranty claim or a fraud claim or anything else. Well, forget fraud, that's not involved in here. But a contract-based claim, these provisions govern.
Except for the fact that they pursued us, and this is what we argued in our attorney's fees argument, they pursued us on an implied warranty.
Right.
And they ignored or were able to ignore all of the express warranty waivers, if you will, and proceed, under Richards versus Powercraft
Right.
On implied warranty. And then the problem that we have as, somebody who wanted to arbitrate under the terms of our contract essentially got gutted, and I don't think they can pick and choose certain portions.
Del Webb wrote, because this is clearly a forum agreement, in 5.5, any controversy, claim or dispute. It didn't say any controversy, but only those controversies and claims that are directly under the terms of this contract. It said any dispute relating to the agreement or your purchase of the house.
Except that those disputes are then governed by the terms of your contract, of which they repudiated those terms, because we had certain defenses. Pulte Del Webb had defenses based upon their contract that would have precluded or at least limited some of the relief that the plaintiffs were ultimately able to get. And that's the difference, is because and sort of goes back to the whole argument of the arbitration, in that there's a lot in the appellee's brief that basically say, well, you participated in this arbitration, therefore you're bound by it. The problem I have with that, and I think the problem that Pulte Del Webb has, is that there was no alternative. I mean, there really wasn't, gee, we're going to take our ball and go home and not play. We had to participate, and we had to fight over fees, and we had to do all of those things.
But it is Del Webb that wrote the arbitration provision,
I agree with that.
and it's a pretty broad provision.
Except that the arbitration provision envisions that the arbitration will be governed by the contract.
But it does say any dispute
Any dispute
or claim.
under the contract, yeah, governed by the contract.
Or your purchase of the home. The phrase is in the disjunctive. Or your purchase
But
of
the
the house.
contract, I'm sorry.
Yeah, please go ahead, sir.
The contract does, though, then govern how those disputes are to be legally enforced and legally looked at. And those defenses, in effect, get gutted by virtue of the implied in law cause of action. I'm out of time. If I can borrow 30 seconds from you, I just go back to the expert fee award. And again, the question of how these cases come about, and to reward the behavior that the court is fully aware of with a $3 million fee award based upon a tortured reading of costs, I think is something the court should look closely at.
Thank you, counsel. Thank both counsel for their arguments, the briefing. We will take this matter under advisement and issue a written decision.
May I make one additional point? I noted that in your briefing, both in the reply and certainly in the answering brief, you inserted, I know this is really techie now, hyperlinks, and they were both very user-friendly, and I would like to say I, for one, really appreciated it. Thank you very much for doing that extra effort.
With that, we'll take a brief recess and let the next case, people in the next case approach.